Professor Babula, I think.
Hello, everyone. How are you?
Okay, here we are. Okay. Welcome and
thank you so much. It's a great event.
Nice, great pleasure to meet you. Yeah.
Nice to meet you all. Nice to see you all.
Okay, so I think we can start. So welcome everyone, all participants, students and speakers and the organizers too, which are here. Mario, thank you. Thank you. So let me introduce myself. Okay, I'm Barbara Boschetti and I'm a professor of administrative law at the Catholic University of Milan. And I'm a very proud and, if I may, active member of the ADiM's EU Lab. And I have a very deep and sincere interest in procedures and smart regulatory strategies provided in the migration field. So this is me. Let me say that I'm really honored to chair this second session of the third ADiM annual conference. So thank you to the organizer for inviting me. Well, I think the rules of the game are really few and very clear. So it's important we respect time limits. I think 13 minutes for each speaker are perfectly fine. Is it okay for you all speakers? Okay, thank you. So that we can have a very great discussion, debate and Q&A session at the end. So thank you, everyone. Well, this second session focuses on a huge topic, managing the external borders. Well, the Commission believes that an integrated, comprehensive and kosher, at least in terms of responsibility, border management is essential to the overall effectiveness of EU policies of migration. We are talking about really a great web of policies, areas, tools, and legal issues. Smuggling, prevention and control, fair and efficient procedures, both asylum and return procedures, integrated systems, IT systems. So we are talking about so many things. This is not a really revolutionary idea, as Mario said before, as the previous speakers said, but still we need to face the challenge. So I'm sure that our distinguished guests today will help us to find out how. Okay, so the floor is yours. The first speaker is Professor Valsamis Mitsilegas. He's Professor of European Criminal Law and Global Security at Queen Mary University of London. His one of the latest book is about the criminalization of migration in Europe. So you are perfect for the task. And the title of your speech is the extraterritorial dimension of anti-smuggling measures. So Professor Mitsilegas, the floor is yours.
Thank you so much for this very kind introduction, Chair. Thank you to the organizers for inviting me. This is a great event, and I congratulate you also for organizing it in the time of the pandemic. I see many friends and colleagues. It would be very nice really to do this in person, but hopefully next year or the year after, you know, we can meet again and discuss the impact, the further impact of the Pact on European migration policy. I will stick to my time, hopefully. If not, please stop me. And I will discuss the evolving EU anti-smuggling policy from the perspective of the border management. I think when we hear about smuggling and trafficking to some extent, our mind goes mostly to repressive policies and to criminal law. Criminal law is relevant and it will be a central part of my presentation. But I think it is important to place the developments of anti-smuggling policy within the context of extraterritorial immigration control. And I think that we see in the field of border management in the European Union a growing and constant trend towards what certain scholars are calling externalization, others are calling it extraterritorial immigration control, and I also call it a form of prevention or preemption. So one of the key strands of EU migration policy is to avoid migrants reaching Europe's external borders in the first place. And this is how, if you like, the policies on migrant smuggling have been evolving over time. In this process, we see in terms of political rhetoric, the increasing securitization of migrant flows, and to some extent, the securitization of search and rescue at sea. So if you read the latest documents in the Pact, but also elsewhere, we have increasingly a shifting rhetoric from protective obligations to the fact that flows are related to and are causing death at sea and serious bodily harm. So this rhetoric is intensified in the field of anti-smuggling policy, where policy documents are accompanied by images of the ruthless smuggler who is responsible really for migrant deaths. And implicit to this is this justification of a policy saying that it would be better if these journeys are not being undertaken in the first place. And underlying that, you also have this linkage of the smuggler with humanitarian rescue and with the role of civil society really in providing search and rescue at sea. So civil society is also viewed as either linked to smugglers or as in itself endangering human life in a sense. So, we have this stigmatization, if you like, or this contamination of search and rescue efforts in political and in policy discourse. So we have this increasing really securitization of the migration flows debate. Now, I want to do, having set out this context, I want to do two things today. First of all, to provide a very short critical overview of where we are in the current EU law on migrant smuggling, focusing specifically on criminal law and how it relates to search and rescue. And secondly, to critically evaluate the recent documents in the Pact. These are documents that are not necessarily the ones that will be centrally discussed. They are towards the bottom of the list of the wide range of legal documents in the Pact, but I think it's worth having a look. So first of all, what do we have today? We have a criminal law framework on migrant smuggling at EU level, which is rather old. So, this is the so-called facilitators package. I want to remind the audience that we take it for granted that we have this package. This is legislation that dates back to 2001 and 2002. So, we have a dual measure, a directive and a framework decision, because this was in the era of the pillars. The European Union before criminal law had been integrated, had been Lisbonized, if you like. And these were initiatives, and I remember at the time, it shows my age as well, that were adopted with minimal scrutiny. There were member states initiatives, so they were tabled by the French government, and the text is very elliptical. So these are, it will take you 3 minutes to read, both the directive and the framework decision. And they have introduced a very broad criminalization of what is called facilitation of unauthorized entry, transit, and stay. And what is really striking is, first of all, and this has been noted by a number of commentators, but also by the United Nations itself, the fact that the criminalization of smuggling deviates from international law, from the main legal source, which is the Palermo Smuggling Protocol, the UN Convention on Transnational Organized Crime in 2000. And the main difference is that in the United Nations international law, smuggling is criminalized only when it involves financial gain. So, because the framing of the Palermo Protocol is that the criminalization of smuggling is part of the fight against organized crime. So this is not really a measure of immigration control or of border management. It is there in order to disrupt organized criminal networks. And the requirement of financial gain persists ever since, also in the interpretive documents by UN organs as regards to the Palermo Convention. This means that it becomes more complicated, if you like, to criminalize humanitarianism and to prosecute actions that are undertaken for purposes other than financial gain. This element, as we know, does not exist in EU law. The facilitators package introduces the possibility of member states to exempt from criminalization some form of humanitarian action, and all the reports show us that it's only in a minority of EU member states that they have followed really this option, and there is a considerable legal uncertainty as regards the extent of criminalization. What we also have in EU law is the Commission revisiting the facilitators package very recently. So, you know, a big exercise on better regulation was conducted by the Commission with the so-called refit package exercise. And there is a lengthy report of the Commission a few years ago telling us why it is not necessary to change the law. Which I found quite a challenging conclusion, especially after all this discussion, both at national and European level, on the dangers of criminalizing humanitarianism. The European Commission, mindful, I think, of the political reality, has said that the legal framework is fine as it is. You know, we could really offer some guidance, perhaps, which we see, and we'll come back to that in the Pact, but there is no need really to modernize this very old pre-Lisbon legal framework. And this is in stark contrast with other areas of criminal law on migration. And I draw your attention to the framework on human trafficking, where we have a very detailed post-Lisbon directive on criminalization of human trafficking, which is really the parallel, if you like, to the smuggling measures. So we have a current EU framework, EU law framework, which is very problematic, both in terms of over-criminalization and in terms of challenges to human rights, but it is also a very old framework, if you like. Now, what has been the impact? And I think those of you who are based in Italy are the leaders, if you like, in highlighting these challenges. And I always follow your lead and try to read, although my Italian is not perfect, your analysis on that. And I think in Italy, there is fertile ground, both in terms of policy and judicial developments, but also academic commentary about the perils of such overcriminalization and, you know, what can happen really in domestic law. And there are four, I think, main issues of concern as regards the criminalization of smuggling. The first one, of course, and you know, we can talk about it further, is the criminalization or the prosecution of humanitarianism. I mean, there is a long range of case law and prosecutions where NGOs are being prosecuted for search and rescue at sea and for humanitarian assistance. And we can talk about, I'm not going to go into detail into that now, but we can discuss later. What we also see within this climate of criminalization, of securitization of humanitarianism, is really the state using also other avenues in order to prosecute. So, you know, I think we have elements whereby it's not necessarily the facilitation offenses that are being used to go after civil society, but also organized crime, anti-mafia legislation, or other forms of national criminal law on organizations. And we can talk about the uses and abuses, if you like, of criminal law in that context. Linked to that is a third element, which is the increasing use of restrictive measures, such as seizure and confiscation. You know, we have seen seizure of boats, for example. And there, I think, again, a variety of excuses have been used. It's not only the hard criminal law, like the organized crime, but it is also issues of environmental regulation or of health and safety. And we'll come back to that, to the health and safety point when I discuss the Pact. And fourthly, we have an increased attempt to regulate civil society. In Italy, one of the measures that had been proposed a few years ago is the so-called code of conduct. So, you know, it's this kind of voluntary, so-called voluntary acceptance by civil society of obligations that it has to follow. And this is really an attempt to some would say to regulate, but others would say to stifle, if you like, humanitarian efforts. And I think what seems to me to really bother the state is own initiative humanitarianism, in a sense, when civil society intervenes in order to plug the gaps, the holes in human rights protection that are left by the state. And the state is not really happy with this, it's not having it. So we have increasing efforts really to regulate the civil society, adopting also quite securitarian discourses. So, you know, in a number of EU member states, we have increasing questions on where do the NGOs find the money? You know, who is behind it? I mean, this is quite dangerous. And yeah, I would really urge you to look at the recent case of the European Court of Justice regarding the treatment of NGOs by Hungary. These are not immigration NGOs. You know, this is the Central European University as an independent organization. The Court of Justice is saying increasingly that the targeting civil society, either by cutting off the funding or by imposing increasing obligations, is contrary to a number of fundamental rights, including the right of freedom of association. So, you know, I think there are very, very serious really concerns, not only from the criminal law perspective, but also from a human rights perspective of the participation of civil society in a democratic society. So, you know, I think and this is all linked to, if you like, what I would call the preventive preemptive web. So, you know, we really want, the state really pushes back on ideas of providing protection and access, if you like, to the territory. What do we have in the Pact? And I will finish with this. We have two documents in the Pact which are relevant. The first one is, I'll tell you the full title. It's the Commission Guidance on the Implementation of EU Rules on Definition and Prevention of the Facilitation of Unauthorized Entry, Transit, and Residence. It is interesting, first of all, that prevention appears in the title. I mean, prevention is not really in the title of the EU law, in a sense. So, you know, so clearly the preventive aim is here. And the Commission, what essentially the Commission has done is that it said in the Pact, we're not going to change the law. So, you know, we have decided that the facilitation package remains, but we're going to issue this guidance aiming, in a sense, to sweeten the pill. That's how I see it, at least. But it is not very satisfactory, I think, what you see here. So, you know, the Commission states that humanitarian assistance that is mandated by law cannot and must not be criminalized, and recommends to member states to implement the humanitarian exception in the facilitation package. This is not binding, of course, this is guidance. Secondly, it is not clear what mandated by law means, in a sense. So, you know, so it is interesting to see that the Commission further states that the definition of humanitarian assistance, as we have in Article 1, Paragraph 2 of the Facilitation Directive, should occur in member states on a case-by-case basis. I mean, this does not provide with much in terms of legal certainty. And what is also interesting is, again, this effort really to circumscribe the humanitarian efforts within the state vision of what is required. And the guidance says that criminalization of search and rescue operations by NGOs is not permitted by EU law if these comply with the relevant legal framework. And again, I wonder what the relevant legal framework is. So, you know, can you really, what will happen if an organization attempts to search and rescue at sea within a framework that has not really been formally approved by the state? So, you know, where the state has its own protocols really for search and rescue and so on and so forth. So the Commission is aware, I think, that there is a problem. It refers to the many studies that have been very critical, highly critical of the current regime, but I think it really does not want to rock the boat. What makes the situation, I think, further problematic is the publication of another document, which is relatively unsung. It's a Commission recommendation, it's a very opaque title, on cooperation among member states concerning operations carried out by vessels owned or operated by private entities for the purpose of search and rescue activities. So this is, you know, you read it and you think, okay, it's about cooperation between member states, but it is really about further controlling civil society. If you read, I mean, the main recommendation here is that member states should exchange information with each other on the activities of civil society in terms of search and rescue. But if you read the recitals, because I think the, reading between the lines, the recitals are very important. Again, it paints a picture of civil society as risk-bearing. I mean, I will draw your attention to two recitals before I close. So recital 9 repeats the mantra that migrant smuggling and trafficking networks take advantage of the rescue operations conducted by private vessels in the Mediterranean. So again, you see the security continuum, which is being attempted between migrant smuggling networks and trafficking networks with civil society. And this has been presented, I think, in a number of EU member states in various policy debates. The other interesting thing, which I find it really fascinating, is that recital 12, talking about the activity of private vessels, talks about that it is a matter of public policy that these vessels are suitably registered and properly equipped to meet the relevant health and safety requirements associated with this activity, so as not to pose a danger to the crew or the persons rescued. So again, you have this requirement for registration, for control of civil society by the state, under the guise, beneath the guise of health and safety. So, the search and rescue unregulated vessels pose a threat to life, to health and safety, not only of the migrants, but also of the crew. So, you see the undertone. And then, you have the recommendation saying that member states should cooperate with each other by exchanging information on these vessels. And this is linked increasingly to efforts by EU member states to increasingly regulate civil society. We saw it also in Greece, where efforts really to create a register of NGO, civil society intervening in migration management is linked to a discourse which really criminalizes these NGOs, where, the authorities are saying that, a number of them do not have any right to operate, and we're really very skeptical about their funding and who is behind their operations. So I would urge caution. I think the Pact doesn't fill me with confidence that much will change in this. The only positive development in my view is that the Commission is clearly aware of the ongoing criticism of over-criminalization and stigmatization in this field. I will stop here. I look forward to the discussion. Thank you.
Thank you, Professor Mitsilegas. I think you really helped us to look at anti-smuggling measures from the perspective of border management. So really, thank you. I think you also highlighted the risks which are associated to what's new in the Pact, and we are really very grateful for that. I think you have a fan. Professor Pitea was really saying yes to everything you were saying. So I think you have a fan, and this is good. Okay, and so I think we will come back to this in the Q&A session. I mean, the role of civil society plays is really very challenging and so interesting. So we will come back to this. So we move forward to our second speaker, Professor Galina Cornelis. She's here, and welcome again. Professor Cornelis is from the Vrije Universiteit Amsterdam. She's associate professor of UN international law, and she's an expert in return procedures and human rights and return procedures. Her last papers are or deal with this huge topic. And so, Professor Cornelis, the floor is yours.
Thank you very much. First of all, thank all the organizers for this really opportunity. I just go through the list of participants, and I saw lots of, I got Leanne fantastic. I wanted to send. Very good to see you. Nice to meet online. Ask a bit about effectiveness of return, also in view of the new pact. And I was thinking I want to do that by showing you a brief image and also by showing you a little bit of an outline what I will be talking about these 12 minutes. So I'm going to share my screen just for a moment and I'll tell you what I plan to do. I hope this will work. Okay, so what I want to address today is that when we talk about the way in which the EU regulates irregular migration, we can see three variables. And these three variables to me are very interesting because they say something about the process of integration, and they also say something about how we can understand effectiveness. Now, the first thing that is really important or striking when we see EU integration in this field, and this is not only when it comes to irregular migration, but it also comes to the fore when we look at the integration in the field of asylum, is that there's a strong emphasis on procedural harmonization. So also when we look at EU policy with regard to return, or with regard to irregular migration, it's mostly on harmonizing procedures. Now, that is quite interesting. As an academic, I find that interesting because when you look at early European integration, it was very often on substantive areas, substantive law, and procedures were something that were up to member states to give shape. I think when we look at EU integration with regard to irregular migration, we see something completely opposite. We see an absence of any substantive ideas, and we see therefore a strong emphasis on form, I would say. And so a good example of this, the most obvious example, of course, is the definition of irregular stay in the return directive is when one doesn't satisfy the conditions for entry on the basis of the Schengen Borders Code, but it also leaves it to national states to decide on whether stay is irregular or not. You see a similar, and I mean, this is very logical in view of the careful guarding of national sovereignty of states, but similarly, states really trying to keep out, insisting on the fact that criminalization of migration would be left out of the process of European integration. So that's one variable. Then a second thing that's very striking is that, and this is of course not only with regard to irregular migration, this is with everything that is regulated by law in contemporary Europe, but it is characterized by a plurality of legal orders. Now, I already said this is not very particular to this field, but I think it brings particular problems when harmonization is mostly procedural, because member states, when it comes to dealing with migration, with irregular migration, but also with asylum, with all these issues, they are characterized by very specific national cultural peculiarity, I would say legal, cultural, administrative law. And the result, and I'm going to argue that a little bit more in depth in the rest of my presentation, the result is that what happens then is that you leave more substantial harmonization. If you have this set up, then more substantive harmonization is going to be achieved by judges. So if the EU legislator is focusing in this way, is choosing to push forward integration in this way, and of course it's the member states. Member states don't want to do substantive integration. They want to keep it procedural. They wanted the things having to do with irregular migration, the Schengen acquis, wanted to keep it very separate from other areas of free movement, for example. So if you want to do that, then you leave it to judges to make substantive decisions. Now, I'm going to discuss a few of these incidences where we see that judges have made these decisions, and I will try to do that in light of some of the more striking changes that the Commission has proposed in the recast for the return proposal. And I will also try to talk a little bit about what does effectiveness mean in this context of procedural harmonization. Now, it's been argued that effectiveness, also when you look a bit at the not the preamble, but the explanatory memorandum to the recast directive, you see that it's really about well, enhancing return rates, effective return, which is much more narrow than a sustainable way of dealing with irregular migration. This is also something when talking with people that work for the Commission, there is no competence, for example, with regard to regularization. Now, that of course in itself doesn't make sense. It only makes sense against political background of integration. But if one realizes that irregular migration, to an extent at least, is also a problem that states create themselves, and that regularization is one of the answers to deal with this problem, it is very strange that this aspect is always kept out of Europeanization. Again, it's very logical in the context of political sensitivities of member states, but the inevitable result is when you start to regulate in this area that judges will have to deal with it, because they cannot say when they are deciding a case, they can't say, I'm not deciding. So what are the more striking changes when it comes to the recast or the proposal for the recast for the return directive? I will very briefly go through them, and then I'll try. I'm not sure how much time I still have left. I didn't really look at my watch. Maybe 6 minutes or something.
You still have no 8 minutes more. Yeah. So.
Perfect. That's very good. Okay. So the proposal in some instances makes it mandatory not to give a voluntary return, a period for voluntary return. The recast also proposes to significantly limit procedural safeguards. In some cases, there are 48 hours to appeal against the return decision, and this is in the case that the return decision is taken in conjunction with a negative decision on the asylum application in a border procedure, when we will be hearing more about the border procedure in a few minutes. There is a new provision that provides for the issuing of entry bans without a return decision. So again, here we see external borders when people are intercepted when they try to leave the EU. They have not before been seen as irregularly staying. They can be served with an entry ban. Now, then there's of course the Article 22 on the border procedure, which is a procedure that will be linked with the border procedure in the asylum acquis, where there is talk about swift returns. And one of the justifications given by the Commission is legal certainty for applicants. There are increased grounds for detention in the proposal for the recast, and detention of irregular migrants will be allowed on grounds of legal or of public order and national security. And let me see, there is, I think that were the main things I wanted to discuss with you. Now, if we go to this last ground, so the increased grounds for detention on public order and national security ground. So had these three variables that I was discussing with you before. What happens now when we look, for instance, at this specific ground? Now, I think what's quite interesting is that what EU action does here is give member states more competences to put people in detention. But how does that relate to the ECHR order, where the ECHR has held that people can not be detained? They can, under Article 5, a sort of preventive detention is not allowed. So just to detain somebody on because that person might be a danger for public order is not allowed under Article 5 of the ECHR. Now, the court in Luxembourg has reflected on how the grounds for detention also in the reception conditions directive, how they relate to the ECHR in a case that was referred by the Dutch Council of State. But I think it's very important to keep in mind that the EU is not member to the ECHR. So the way in which the Court of Justice carries out this well, the legal assessment of this question per definition is different from that of a national court. That's a first difference. A second difference is that the Court of Justice of the EU doesn't decide in individual cases. So it only decides about the interpretation and application of EU law. A national judge also has to decide about application of the ECHR, application of international law. So these national legal orders are defined by many more legal orders, which makes it more difficult to do a decision and more difficult to reconcile these different requirements. Now, what happens? So to make it a little bit more concrete, so what would happen if an irregular migrant is detained on a public order ground in one member state, and that irregular migrant goes to court to challenge the detention? My question would be, how would the proportionality of that measure, how can that be measured? Because if you would do it in the context of the ECHR, you would have to measure it with the duration, for example. Would a duration of somebody that's very dangerous, measure that with the aim of protecting the public or with the aim of deportation? So these things become very difficult, and then judges will have to make a decision. That decision may not necessarily align with substantive or wishes or ideas that national member states have regarding substantive harmonization. Another example that I wanted to show where maybe the proposal for the recast is problematic, but where we have already seen judges making steps, is in the space that is increasingly being carved out between irregular migration on the one hand and the asylum acquis on the other hand. And this is very relevant, I think, for the limitation of procedural safeguards, especially in the context of the border procedure, which I already mentioned, is 48 hours. So if one is in a border procedure and gets a negative decision, 8 hours period for appeal. This is probably motivated by the idea that all grounds for providing somebody with the protection in international law have already been assessed carefully. We will be hearing more about that later. But it's also very important, I think, to underline that the assessment whether deportation, expulsion would be in violation of the prohibition of non-refoulement in the return directive is a different one than the assessment that is being made on the basis of the asylum acquis. So the Court of Justice has in a way Europeanized the protection against non-refoulement of, for example, seriously ill people. Before, this was an area that was left outside of European integration. Because of the return directive, because of cases such as Abdida, it has become European, and the court has given directions for very substantively how states have to act and how they cannot act. A last thing I wanted to mention, maybe not so much with regard to new specific provisions in the proposal for the recast. But I wanted to briefly say something also about the criminalization of migration, because that has been something that has been left out so much from the return directive. States really wanted to keep that for their within their own sovereign sphere. And here again, we see that because of judicial interactions between different legal orders, so for example, Dutch courts that were puzzling how to, well, Dutch and Italian, of course, I should really not forget the Italian cases that where the criminalization cases started, but that has given a very interesting dynamic we have seen there between how the Court of Justice interprets effectiveness and the ensuing protection that can be that a migrant can then
sorry,
get.
We have just 1 minute more, and not, is it enough? Sorry. Thank you.
Yeah, I'm gonna stop in a minute. So in a very recent case, so that's what I mean with incremental harmonization. In a very recent case referred by the Dutch Council of State, we see that also the Court of Justice refers to case law of the European Court of Human Rights to say that well, measures that deprive irregular migrants of their liberty have to be in accordance with the principle of legality, and refers to a Portuguese case, criminal case. So we see this incremental harmonization, and I think it is something that we will be seeing the coming years if this is the way in which harmonization proceeds. Thank you.
Thank you, Professor Cornelis. I fully agree with you. The Pact focuses mainly on procedural harmonization, and for sure justices and courts, they fill the gap, but this is not enough, as you were saying, because we live in a plural legal system, and the EU one is a plural legal system, and so I mean justices are not enough for filling the gap, and I fully agree with you. I hope we have time to come back to this at the end, because I have a few questions, so I hope we have time at the end before you leave. So we come now to our third speaker, Dr. Niovi Babula from Queen Mary University of London. She is lecturer in migration and security, and she is also associate editor in the New Journal of European Criminal Law, and she collaborates with the Odysseus Academic Network. So thank you for being with us, Niovi. I hope this is the correct pronunciation. Is it? Yeah? Okay.
Yes,
thank you.
it's perfect.
Okay, thank you.
So much.
Thank you. So you have the floor. Thank you. Interoperability and databases, promises and problems.
Thank you so much for the kind introduction and the kind invite to contribute to this very timely event on the Pact. And congratulations, of course, to the organizers for pulling together this amazing event. So my presentation today will focus on an aspect of the fact that in comparison to other issues is quite understandably relatively under the radar. And it involves information systems, particularly the refurbishment of Eurodac in an interoperable environment, which features in the Pact in the form of a recast Eurodac proposal, as well as its implications, obviously, on asylum seekers and irregular migrants. So a brief outline of Eurodac is necessary to lay the foundations of the subsequent analysis. So Eurodac, as you all know, has been traditionally linked with the Dublin system. It has been considered the digital sidekick of Dublin, which was conceptualized back in the 90s so as to assist in the determination of the member state responsible for an asylum claim. Therefore, its necessity and proportionality has always been inextricably linked to the success or failure of the Dublin system. So the Eurodac regulation in its basic form requires the collection, storage and processing primarily of fingerprints of asylum seekers above the age of 14, as well as irregular migrants apprehended in connection to the crossing of the external border irregularly. In turn, fingerprints of migrants found irregularly present on national territory may only be compared, and it's not centrally stored. So Eurodac has already undergone one rather adventurous reform back in 2013, and in 2016, the Commission tabled another proposal for a full refurbishment of Eurodac as part of the third generation measures of the Common European Asylum System. So the 2016 proposal encompassed a series of reforms of Eurodac on various accounts. From a material scope, the system was envisaged not only to be used in support of Dublin, but also to be used for wider migration purposes, particularly related to return of failed applicants and irregular migrants. So this premise impacted on various other modalities of the system, requiring the lower of the fingerprinting age from the age of 14 to the age of 6, allegedly in order to protect minors, as well as the storage of data of irregular migrants found on national territory would now feature in the system, even though now may only be compared. This change was introduced basically to facilitate national authorities that would rely solely on Eurodac data without having to bilaterally contact other member states in order to find more information, because Eurodac only contained fingerprints after all. So again, because of this reform, Eurodac would not only include fingerprints, but also photographs and other personal data. And finally, the retention period from 18 months would increase to 5 years. So behind this reform, there are various reasons that prompted it. I have discerned 4 ones. One is the failure of the Dublin system and the implied need to legitimize the existence of Eurodac on another basis. Second, the de facto use of Eurodac as an identification tool, even though identification never featured in the mandate of Eurodac. Third, the reinforced efforts to return irregular migrants. And fourth, the need to align Eurodac limited rules with other information systems in an era of interoperability where all information systems should be speaking to each other and aggregate data from different sources. And therefore, a level playing field was necessary. One example in that respect is the fact that the visa information system on visa applicants' data is also under reform, with lowering the fingerprinting age, again from the age of 12 to the age of 6, which basically leads me to argue that the rationales behind certain supposedly protective features of Eurodac, for example, in the case of minors here, were only disguised efforts in order to implement interoperability. And obviously, these concerns and these thoughts call into question the necessity of the reform, because all these do not relate with the Eurodac per se or the Dublin system per se, but relate to other related issues. So in terms of what happened in the negotiations, the adoption of the revised Eurodac regulation was halted due to the package approach to all the dossiers related to the Common European Asylum System. Therefore, even though there was an agreement between the Parliament and the Council, there was no adoption of the recast Eurodac regulation in the wake of the fate of other instruments, primarily Dublin 4. So during the negotiations, further reforms were introduced, primarily the use of the system also for resettlement purposes. Therefore, individuals who were under EU or national resettlement schemes were also to be included in Eurodac. So how is that related with the Pact? Basically, the new Pact capitalizes on the 2016 proposal and builds on the provisional agreement between the co-legislators and provides certain additional reforms. So objectives now of Eurodac will be to support EU policies on asylum, irregular migration, and resettlement. And in addition to the aforementioned reforms, which are fully maintained, the proposal foresees the use of Eurodac data to produce a series of information and statistics on the number of applicants, because now the system stores applications, not numbers of applicants, and other statistical data on arrivals and secondary movements. Another important addition is the creation of a new category of persons, a distinct one from the previous, which are persons disembarked following a search and rescue operation. Here, the rationale has been that member states of disembarkation face specific challenges as they cannot apply the search and rescue disembarkations the same tools as for irregular crossings by land or air. So overall, there are various challenges one could discern in relation to the new purposes of Eurodac, many of whom relate obviously to the 2016 proposal, which I fear that because of the approach are not going to be subject to much negotiation at this stage. For instance, we have the addition of another biometric identifier, which is in the form of a photograph, a facial image, which is a special category of data, which has been introduced barely for reasons of administrative convenience in order to assist in cross-checking of identities. At the same time, even though a new biometric identifier has been introduced, the rule of fingerprinting individuals with a full set of fingerprints has not been reconsidered, even though on the basis of the data minimization principle, two biometric identifiers are not really necessary and some kind of renegotiation could have taken place. The fingerprinting of minors is another major issue. Obviously, the fingerprints of minors are not fully reliable and are subject to change. This may lead to increased false matches. And importantly, it is quite difficult to explain to a minor the purposes of fingerprinting. Already, research shows that it's difficult for asylum seekers, adult asylum seekers, to understand how Eurodac operates, let alone to try to explain it to a minor. Also, it is quite striking that the proposal did not reconsider the 10-year retention period of asylum seekers' personal data. So we have a series of problems already from that, from the proposal, the previous one. So generally, the emphasis on returns and irregular migrants raises an eyebrow for an additional reason. So I will go back and see and explain to you how Eurodac was initially conceived. And there it is quite interesting to see that initially Eurodac was not supposed at all to store data on irregular migrants. It was a last-minute addition which found strong resistance because there were fears that it would lead to function creep. Fast forward to today, we see that these fears back in the 90s have indeed materialized in the sense that a secondary target group of Eurodac, irregular migrants, has actually led to a complete redesign of the system. So basically, because the categories of data are pretty much the same, we see that Eurodac pretty much to a certain extent equates asylum seekers and irregular migrants, at least in terms of the data collected. And because the majority of the amendment rules are meant to reinforce return procedures and do not relate to the initial purpose of Eurodac as a Dublin tool, I think it could be argued that all these purposes that I mentioned, resettlement, irregular migration, and asylum, should now be considered on an equal footing, all of them primary ones with no hierarchy amongst them. One potential avenue to attack this development in Eurodac would be the purpose limitation principle, which requires that data must be collected for specified purposes and must not be processed for other purposes which are incompatible with the original ones. So here the problem is that these purposes could overall be considered as compatible one to another. And of course, if Eurodac can be accessed by police authorities and this can be considered as compatible with the original purpose of Eurodac, I do not see how the purpose limitation principle can be arguably invoked. However, there could be considered that there is a rule of law problem relating to the foreseeability of the use of the data. So imagine that today an asylum seeker has their data registered in Eurodac, they are fingerprinted, they are provided information about the use of the data for Dublin-related purposes, and in a couple of years, when the new proposal is finally adopted, the same asylum seeker may find themselves, after a failed application, subject to a return procedure on the basis of data that provided for the purpose of an asylum procedure. So this reconfiguration of Eurodac as a tool for return procedures is also likely to eliminate any level of trust, especially if individuals may find themselves in between these procedures. So Eurodac has been a tool in a broader context of providing protection to those in need, and in cases where such registration takes place as a preliminary cog in the EU machinery for asylum seekers to get access to the national territory, we see, on the other hand, the operation of Eurodac return procedures. It is in order to take the asylum seeker or the irregular migrant outside any protection scheme. One is for protection, the other is for the lack of protection. Coupled with the possibility of sanctioning those unwilling to be fingerprinted, I think that irregular migrants and asylum seekers are going to find themselves with their backs against a wall. So as for the rules relating to the interoperability of Eurodac with other information systems, this is not at all a surprise. These rules have already been adopted, arguably some of them without being supported by the current mandate of Eurodac. For instance, the use of Eurodac in order to find individuals with multiple identities. However, the rules are meant, in the revised proposal, are meant to align Eurodac with interoperability and ETIAS regulations. One can argue against the quite dubious decision-making process, but again, this is a fait accompli. Another final issue that I wanted to highlight relates to the application of Eurodac in screening procedures. In that respect, again, I would like to do a flashback and note that the term apprehended in connection with an irregular crossing of an external border has been interpreted, at least by the Council back in 2000, as including situations of migrants apprehended beyond the external border while they are still en route. Therefore, we will see that Eurodac procedures may take place outside the EU territory in fast-track return procedures. As Valsamis mentioned earlier, this means that Eurodac is also a tool of deterrence, a tool of prevention, and a testament, I think, to an implied presumption of irregularity that will trigger return procedure. So I think I will stop here with these quite dystopian concerns and thoughts about Eurodac. I think it's evident that once data is collected, there is complete lack of control. There are increased difficulties to uphold data protection rights, and a greediness of the EU legislator to collect all the more data, sometimes merely for the sake of creating statistics in order to legitimize, in retrospect, policies that were initially unsupported by solid evidence. So I leave it to these comments, and I look forward to the Q&A session. Thank you.
Thank you, Dr. Babula. Thank you. Really, thank you. Interoperability is key, but what we see here, if I get it right, I mean, is that we have many promises and even more problems. And I really like to know if some of the risks you highlighted are somehow connected to the risks that Professor Mitsilegas was talking about before for civil society connected to or deriving from anti-smuggling measures. So I would like to ask you something about this. I mean, risks connected to the use or the wrong use of data stored in these databases for the civil society. So not only for migrants, but also for the civil society. This is really very interesting. So we come to our fourth speaker, which is Professor Cesare Pitea from the Università degli Studi di Milano. He's an associate professor of international law. And the title of his speech is really, for me, is really what I want to hear. I mean, what I wanted to hear in this conference. So is really at the core of my studies. And so border procedure efficiency at the expenses of due process. This is a very big question. So the floor is yours. We cannot hear you.
I always do that. Thank you very much for the floor, and thank you to Mario and the other organizers and friends for inviting me to this conference, where I see from distance a lot of friends and esteemed colleague. So when Mario kindly invited me and submitted to me this topic, of course I accepted very enthusiastically. But as I was reflecting on this, I was asking myself, is this a rhetorical question or a real question? And I will try to tell you why. So efficiency is a sort of obsession, a political obsession in which the legal reform take place. But it's not the only one. It's not the only political obsession. The other political obsession is prevention of abuse, which goes hand in hand with efficiency. So we need to prevent abuse of the right to seek protection, and we have to do this efficiently, because we can't have too much of our scarce resources invested in this. And this is very important, because efficiency goes with good use of resources and of scarce resources. And of course, I see this is a widely shared point. What I don't see behind the reform is a serious reflection, not only on the root causes of migrations, but also the effect that the lack of legal migration pathways has on the emergency and on the need to abuse of the asylum procedure. So the border procedure is one, I think, of the most important, interesting innovation, well, the change in the border procedure that is contained in the Pact. In all the documents, starting from the political documents to the explanatory memorandum, the recitas and the provisions that are introduced, we find repeated allegiance to procedural guarantees and full and complete examination of the application. I found this disturbing, because we know that the procedural guarantees, as far as they are an expression of fundamental rights, must be protected, afforded, and also a full and complete examination of the application is required under international law on asylum and human rights law. So why does the legislator need to repeat this all the time? Well, the idea is that excusatio non petita, that in fact, in the back of the mind is there is the knowledge that these rights cannot be guaranteed in the conditions set forth by the legal framework. A legal framework that cannot be just analyzed in the abstract, but has always to be put in relation to the reality that most of the people around this table know, because guarantees are guarantees only if they work as guarantees, not if they are guarantees on paper. So before going to the border procedure, let me talk very briefly about the pre-screening, because here already we have a first border procedure, which is called pre-screening. In 5 days, there is a sort of triage of the migrants at border to put them in the right procedure. And well, in theory, the choice of the individual to apply for protection should not be precluded. It should be an assistance to tell them what they have to do. But then we know that in practice, it can be very different. In practice, this screening risks to preclude altogether access to the asylum procedure, especially to the most vulnerable that have not the means to understand that this is happening. And there is no guarantees. There is a very weak independent monitoring mechanism that will have to be set up, and we will see with which guarantees and powers. Moving to the border procedure, there are 5 aspects that I want to highlight. The first is that the proposed amendment extends the grounds for border procedure. And here there are 2 things that are interesting to me. The first is a conceptual shift in identifying the grounds. So it's clearly the idea is that those applications that are doomed to fail must go through this procedure. But here, this is just a second level of identification. The first level of identification is how did the people reach? And this suggests that if you reach in a certain way, then probably also your application is doomed to fail. I think it's a very important aspect if we look at the discursive function of law. And the other worrying aspect is that for the first time, it is a quantitative method is introduced to measure whether an application is doomed to fail. So you can be subject to this border procedure if you come from a country who has a rate of acceptance of asylum application that is less than 20%. And we know, like there are a lot of studies on this. I'm sure most of you know them better than me. That this is no indicator of anything, because the differences in different systems, biased systems, non-functioning systems. So it's a very difficult criterion to accept. The second element is short deadlines. It has already been said with regard to the deadline to to one of the final deadline to appeal against a return decision. So the person comes to the border, 5 days for the screening, 5 days to apply, and then 12 weeks to complete the application, including the appeal, and the possibility of another 12 weeks to complete the return procedure. Very tight accelerated procedure. The third point is, I call it crowded spaces, because this is the probably legally speaking, the most challenging aspect of this proposal. Where first of all, I find quite disturbing the provisions on location of the asylum seeker, this idea that you can take the people and move them to one country to the other with a relocation, no relevance of the individual will. So it's just packages that you can move from a country to another, and possibly from a place at the border to another place, but still at the border. So it is reasonable, like think about Italy, you arrive by sea, you arrive in Sicily there is no space. It is more reasonable in terms of the proposal to move these people to Trieste than moving them to, I don't know, Rome, because Trieste is a border and Rome is not. That's quite disturbing to me, at least. But the most challenging aspect is the unclear demarcation between detention and reception. Because what is very clear from the proposal is that these persons that are, these applicants that are subject to the border procedure do not have the right to be admitted to the territory. So either this is just like a legal characterization, so you don't have the right, then you go, but you don't have the right to go, which is difficult for me to understand. Maybe some of you have some ideas of the purpose of this idea, of this situation. Or it means that they cannot physically access the territory. But then if they cannot physically access the territory, in practice, this means that they will be detained. So this enters in direct conflict with the reception directive, which provides explicitly that detention of the asylum seekers cannot be the rule. And also the other concern is the conditions of detention, because we don't have to forget that we're talking about efficiency. So of course, this system could work if you put powered into it a lot of money, a lot of resources. So big spaces at the border with nice houses, with a lot of resources for assistance, which means intercultural mediation, legal assistance, interpretation that can put the legal guarantees and the procedural guarantees into practice in a very short time, and the possibility to walk around, not be really confined. So to have a sufficient space to characterize this as a limitation to the freedom of movement and not as detention. And on this, it's also very interesting because on the characterization of the permanence in the border area, in the transit area, depends also one other consideration. So the proposal makes optional for states, for member states, to basically not subject the person that should otherwise be subject to the procedure when there is no realistic prospect of a deportation, basically. But if there is no realistic prospect of deportation and this is detention cannot be prolonged, because we know under Article 5 of the European Convention, only the detention which is really reasonably geared towards detention can be accepted. Fourth point, extended scope of the no right to remain, which is closely connected. So we have all this accelerated procedure in confined space in a very short time. Well, we still have a remedy, not so much. Not so much, because also the proposal extends the grounds for no right to remain. So it means that we have a problem with the guarantees of non-refoulement. And here, a short point I want to make is that this idea that having a piecemeal approach to assessing non-refoulement is not very bright. So they have no right to remain, but they have the right to ask for an interim measure to check whether they basically there is a non-refoulement obligation, but then it means that the interim decision tend to overlap with the merits. So why don't go just to the merits? Recognize the right to is that efficient to have the same judge looking twice at the same thing, just to decide if the person has to remain pending the completion of the judicial procedures. And then the last point is that, unfortunately, as we all know, supranational checks and balances or remedies have become very weak, since we know that on the one hand, and I'm referring especially to the European Court of Human Rights, there is a growing tendency to the proceduralization of control over the respect of non-refoulement on the one hand. And on the other hand, well, we have a whole list of decisions now from the Grand Chamber in particular that show clearly that rights can be guaranteed to a less extent at borders. So my conclusion is what this picture points at is that, well, this is nothing new, first of all. It's just the achievement or the continuation of something, of some political and legal developments that have been there since, well, the inception of the common European asylum system. But here, maybe there is even a quality leap. Well, the criticism to the system is that it was not really aimed at providing protection, but protection is seen as a necessity or as a burden. And the real aim of the legal regulation is to avoid granting protection or use resources for non-meritorious applicants. This has always been identified as the real objective of the common European asylum system. Here, I think we have an add-on, an addition, and the addition is that now it seems that the objective is to physically avoid the entry into the territory of Europe of those that are not recognized as having the right to asylum or protection. So the shift is from the right to apply and the right and the substantive right. So the overall impression is that people here are treated as numbers, and when people are treated as numbers, it's very unlikely that their rights will seriously be taken into account. The second point, concluding point, is that there is no efficiency without resources. So if you pursue the, so to speak, neoliberal ideal of efficiency, and you couple this with the populist anxiety about using the scarce resource for the migrants instead of us, the nationals, then it's very clear that you can't guarantee rights and have efficiency, because efficiency, rights, and resources are, well, one of the three must be, or lack of resources must be out of the pictures. And here I think that it's evident that the part that will be sacrificed is the rights. In practice, is not the lack of resources or the efficiency. And my last consideration refers to what Professor Sabino Mario said before, that here the impression is that lacking a serious reflection on legal pathways for migration, the only choice we have is to, work within the limits of confinement politics and confinement rules and try to improve human rights. So my question is, do not we run the risk that any move or attempt to improve human rights in this situation will legitimize these practices that are inherently incompatible with the protection of basic rights and due process, rather than contributing to correct them in the way we seek. So that's my reflection on this very complex topic, and thank you for listening.
Thank you, Professor Pitea. From your words, what I see, what we see is that when applied to procedures, to border procedures, the so-called integrated approach to border management unveils many dark sides. And what we also see is a new fight, as Professor Cornelis was saying before, between the substance and the procedural side of migration, at least at the border, where the substance is made of people, is made of bodies, is made of human rights. So thank you again for raising this very for letting this dark side come to the sun, we can say, to the light. So now the time has come for our last speaker, which is Dr. Iris Goldner-Lang from the University of Zagreb. She is a Jean Monnet professor and holder of the UNESCO Chair on Free Movement of People, Migration and Intercultural Dialogue at the University of Zagreb, as I was saying before. So Iris, the floor is yours. You have 30 minutes. Thank you.
Thank you very much. I would first like to thank the Academy of Law and Migration, in particular Mario Savino, Alessandro Bufalini, and Daniela Vitiello for organizing this timely event and for the invitation. And being the last obstacle, which is keeping you away from your dinner and a well-deserved daily break, I will try to be as concise as possible and hopefully also interesting. So the aim of my speech is to make a connection between the Migration Pact and the EU budget by discussing the impact of the Migration Pact on the next multi-annual financial framework for the period from 2021 to 2027. I will try to address two questions. First, whether the Migration Pact generates new costs for the EU and its member states. And second, whether it could impact the negotiations on the new MFF and possibly redirect the way money will be spent. Before embarking on the discussion of the financial impact of the Migration Pact, I will start with a brief account of the current state of affairs related to the new multi-annual financial framework, which is essential for the understanding of the issues that I want to discuss. In this respect, it is important to understand that the timing of the Commission's proposal of the Migration Pact coincides with the final phase of the extremely difficult and lingering negotiations on the adoption of the next multi-annual financial framework and the Next Generation EU Recovery Fund. The agreement among member states on the next 7-year budget ended at the longest ever meeting of the European Council on the 21st of July. And according to the European Council conclusions, EU leaders agreed that the next MFF would amount to 1,074.3 billion euros, with the additional 750 billion euros for the Recovery Fund. Out of that amount, a total of 22.7 billion euros is proposed under the heading 4, titled Migration and Border Management. And out of this amount of 22.7 billion euros, 8.7 billion is dedicated to Asylum and Migration Fund, 5.5 to Integrated Border Management Fund, and 5.1 to the reinforced European Border and Coast Guard Agency. In addition, according to the European Council conclusions, the external dimension of the migration would be an important component of the so-called NDICI, which is shortened for the Neighborhood Development and International Cooperation Instrument. And it's intended to streamline the funding of the EU's external action by merging all the 10 existing regulations into one, and whose financial envelope will be 70.8 billion euros. Now, 2 points need to be made here. First, these amounts represent a significant increase in comparison to the 2014-2020 10 billion euros spent on migration and asylum. However, at the same time, they also amount to around more than 25% decrease in comparison to the proposal made by the European Commission for the new budgetary period. Second, the final deal on the new MFF is still pending as we speak. So far, member states have failed to reach an agreement on the deal with the European Parliament, and this could potentially undermine the deployment of the funds from the 1st of January 2021. Since nothing is agreed until everything is agreed, we have to wait and see the final budget deal on migration and asylum. In these uncertain circumstances, the Commission's proposal of a migration pact is another variable contributing to the complexity or even unpredictability of the EU's and member states' future spending on migration and asylum. And in this respect, I would like to raise 3 points. First, I would like to address the impact of the migration pact on future spending on migration and asylum by discussing whether the expenses incurred by the new tasks envisaged by the migration pact are compatible with the new MFF, or whether the new tasks would require additional financial resources. Now, if you look at the migration pact, according to the Commission, all expenses resulting from the migration pact can be covered under the new MFF. Consequently, no additional financial or human resources are requested in the Commission's legislative proposals. However, it is evident that screening and border procedures are likely to require some additional funding for the infrastructure, for hiring of additional staff, for setting up of an independent monitoring mechanism, and for a number of other related costs. Consequently, member states have not been convinced by the wording of the legislative proposals that no extra funding will be needed, and they now insist on laying down the specifics of the screening, border return procedures that will define who does what, who pays for what, for each single step of the procedures, and whether the resources come from the national or the EU budget. Now, the current EU budget covers only a minor part of national financial needs in migration and asylum. Most expenditure for identification, for reception, for processing of asylum claims, for detention, come directly from the national budgets of the host member states, whereas the EU budget plays only a complementary role. It is doubtful, in my opinion, whether this is going to change significantly in the direction of the predominance of the EU budgetary participation, whereas a more even distribution of costs among member states also remains questionable. For example, the newly forged concept of return sponsorship envisaged by Article 55 of the proposal for an asylum and migration management regulation does not impose a clear obligation on the sponsoring member state to finance the return of irregular migrants, but envisages that the sponsoring activities could be limited to activities such as counseling on return and reintegration of third country nationals, or to supporting or leading policy dialogues with third country authorities for the purpose of facilitating readmission. Such sponsorship is not promising from the perspective of relieving the logistical and financial pressure from the host member states, and in terms of promoting the principle of solidarity. In this context, one should make sure that the proposed screening, border, and return sponsorship procedures, which will be implemented not only in the interest of the geographically most exposed member states, but the whole of the EU, do not put excessive financial and logistical pressure on the bordering member states, but that these pressures are adequately supported both from the EU budget and by other member states. The second issue that I would like to discuss is the position of the external dimension of migration in the new pact and its impact on future budgetary expenditure. Now, both the current proposal of the new MFF and the Migration Pact emphasize the importance of the external dimension of migration through cooperation with third countries on migration management and security. In addition, both the Commission's proposal of the new MFF as well as the Migration Pact additionally foresee that 10% of the budget of NDICI, this neighborhood instrument, is earmarked for migration management projects in origin and transit countries. On the other hand, the 10% target is not explicitly mentioned in the European Council conclusions for the new MFF. Additionally, the Migration Pact states that development assistance will be targeted as needed to those countries with a significant migration dimension. Now, the inclusion of the 10% target in the Migration Pact, an explicit connection between development aid and the EU's migration objectives could have a triple effect. First, it could steer the MFF negotiations in the direction of including the 10% target in the final agreement on the next budgetary period. Second, by providing future development aid primarily to third countries on major migratory routes towards the EU, the Migration Pact makes the allocation of development aid conditional on the EU's political interests and not on the actual needs of the respective third countries. And thirdly, the Pact redirects development aid objectives of at least 10% of NDICI funds, which is very difficult to pronounce, to migration and border management objectives. Why is this problematic? It's problematic as the priorities of the external dimension of EU migration and asylum policies are not necessarily coherent with the development aid, which is the reduction or eradication of poverty. On the contrary, by making at least 10% of the EU's development aid towards third countries conditional on their cooperation in readmission and border management, the EU could change the objectives of its development aid as stipulated by Article 208, paragraph 1 of the Treaty on the Functioning of the European Union. Finally, and this is my last point, there will be at least a theoretical possibility. A member state could be exempt from the asylum and migration funding in case it breaches the rule of law while using the EU funds for the implementation of the tasks foreseen by the Migration Pact. Namely, after several years of uncertainty whether the rule of law conditionality will ever come into force or not, today the Council Presidency and the European Parliament reached a provisional agreement on the new conditionality regime, which will link the member states' violations of the rule of law with the possibility to suspend EU payments to such member states that are breaching the rule of law. In theory, this could result in the freezing of EU migration and asylum funds to a member state which has breached EU values when implementing certain activities financed from the asylum and migration budget. And this could be based on the Schengen evaluation report or, for example, the EU Agency for Asylum Evaluation and Monitoring Mechanism report. That's it for me. Thank you.
Thank you, Iris. Thank you. So I have a big question for you. Are we still in the deadlock? This is the question for you. And is there a way out? Because it seems that we have so many tasks and then not so many resources, so that the new Pact is not that convincing. I mean, it's not the Pact, but the financial side of the Pact. So it's not that convincing. So this is a question for you. But the Q&A is starting in a while, and if you agree, I would like to give the floor to Galina, to Professor Cornelis, because she has to leave. I don't know, is she with us, still with us? Because I know she has to.
I'm still here.
Okay, thank you, thank you. So I'd like to ask everyone, if you have questions for Professor Cornelis, this is the time, because she has to leave. So we collect questions. Okay, I see that there are questions for Professor Mitsilekas, so in a while. But if you do have questions for Professor Cornelis, please, this is the time. I have one question. Now, what I believe is that the procedural side and the substantive side are really strictly connected. So they are like two sides of one coin. So it's not possible to separate, I mean, the one from the other. This is my point, my feeling. But I would like to go to the substantive side, and I would like to ask you, what would you suggest in order to implement harmonization from, I mean, the substantive perspective? So this is my question.
I have to apologize because I think it's unstable. I heard.
Yeah.
You asked me about the, yeah.
Yeah, no, I was asking you something about the substantive harmonization. So what would you suggest? I mean, what could the EU legislation do at this regard, in this respect?
Okay, so of course I have a personal view on how one could deal with irregular migration, but I think I think this is also the general consensus, maybe also listening to the other speakers, but but the procedural harmonization goes hand in hand with a very restrictive approach. And there's a lack of awareness of the fact that irregular migration to an extent is a problem that states create themselves. So if you do not want to address issues such as regularization on the EU level, you're not going to solve it. So that would be my solution. There should be more, more discussions on substantive harmonization, and that should not just be restrictive, obviously, because that is also not going to solve the problem. I think this is the same with the border procedure that we had a really interesting presentation on it. And I mean, you see a similar mechanism there. You cannot kind of think of a new procedure just to solve problems with Dublin. It's just not going to work. It will be replaced to yet another area. And then in 5 years' time, we have to think of another procedure again. Mm-hmm. So more creativity and more thorough engagement and not short term.
Okay, so despite the many policies involved, there's still something out, some policies out, which are the most important probably for balancing the entire and the overall context, as Mario was saying before, legal migration and regularization, as you were suggesting. So thank you, Galina. If you have to leave, you were free to go. I mean, and thank you for being with us. I don't know if there are other questions for you, but otherwise they can, I think, email you and you will be happy to answer.
Definitely.
Yeah.
And wish you a very fruitful discussion. Thank you very much and hope to see you again. Okay.
Yeah, you too.
Bye-bye.
Thank you. Thank you. Bye. Thank you so much. Thank you. So I have questions for everyone, but I see there are questions from the floor. So I see Angelo Marletta has a question for, Professor Mitzilegas, and then Francesca Cancellara. So if you want, Angelo, you have the floor.
Thank you very much. Can you hear me?
Yes, we can.
I'm Angelo Marletta. I have a question for Professor Mitzilegas. With regard to the facilitators package, you mentioned that this is actually an old set of instruments, and that we have actually an optional clause of exemption for humanitarian assistance in the directive defining the offense of facilitation of regular entry and transit in this case. I would like to ask you just one question with regard to the optional nature of this kind of clause. Can we consider actually the insertion of an optional clause in a directive in line with the principle of legality of offenses of the Article 49 of the Charter? And my doubt is with regard also more general terms, but having in a directive optional clause which allows to exempt or not the member state which is implementing the directive, a certain kind of conduct which is quite relevant also in the definition of what is actually the actual actus reus that we, or the actual conduct we want to criminalize, is something that we can consider legitimate in light of the Charter and Article 49.
Can I respond? Yes.
Yes. Thank you.
Thank you, Angelo, for the question. I think there are two related points to your question. The first one is the legality point. For all my critique of the current regime, I'm not as concerned about the principle of legality with regard to directives or to framework decisions. And we see it also after Lisbon. I think the main means of producing criminal law is via directives, and directives give member states the leeway to implement. So I would examine legality always at the national level. there are issues, obviously, of legal certainty, and there are issues of harmonization, because obviously, you know, if you have an exception, and we know from the Commission reports that, you know, different states can follow different models on this. And, you know, there is, and the implementation and the practice is also very problematic as well. Even if states follow the same approach, always, I think, how prosecutions are being initiated, you know, reflect certain priorities at national level. For me, the main problem with this is that, first of all, there is a general philosophical discussion, and very real, following what Galina mentioned as well, about whether criminal law is the right way of dealing with migration management. I mean, I have my doubts, but that's a broader discussion. But secondly, it is also that I refer to these old instruments because, you know, hasn't really been a clear decision or discussion at EU level about what these measures are for. So, you know, their legal bases are in the old treaties in the field of migration management. But, you know, are they really migration management measures? Are they security measures? You know, what are they, in a sense? The United Nations have made a choice, which we may agree or disagree with, and they have framed it as an organized crime issue. I mean, you can argue that this is too narrow or that's not enough, but at least it's a conscious choice and it has been justified. Also in the explanatory notes and the subsequent reports. In the EU, we have nothing. We have a very minimalistic piece of legislation, which is, it upgrades it to call it a package in a sense. I mean, you know very well that if you read these documents, they're very, very minimal, elliptical. So, you know, but what do we want this for? And that's why I've been so critical also in my writings about the Commission's evaluation exercise, because that was a real missed opportunity to improve, rethink really how we respond legally to this phenomenon.
Thank you, Professor. I know we have other questions for you, but before that, I think it's better we collect if we collect all the questions, because we do have only 50 minutes left. So it's time to collect the questions, and then I leave you the time for answering to them. I think the first one is Francesca Cancellaro.
Good evening, can you hear me?
Yes, yeah. Yes.
Thank you. Thank you very much to all the speakers for their inspiring presentations. I'd like to ask Balsamis Mistilegas a question too. Hi, Balsamis. You said that the Commission is aware of the overcriminalization of solidarity and humanitarian assistance, and I agree, I totally agree, but at the same time, I have the impression that is not the political and the historical context in which it's easy to renounce to the criminal law tool with the direct legislative intervention, especially at the European level. Considering the last two documents you mentioned in your presentation, do you think that the Commission is trying to suggest the member states to implement or to use more preventive measures, maybe asking NGOs and the civil society more in general, strict administrative requirements, which is at least a way to control their activities, instead of continuing to put in place a real criminalization? Thank you.
And then we have Stefano Zirulia for, I think
yes.
you have.
Thank you. I have also a question for Professor Mistilegas, whom I take this opportunity to greet. And well, you recall that the EU legislation on irregular migration is quite old, and as the packages was enacted in 2002, and we all remember that that time was right after 9/11 attacks in the US. So now in September, the EU Commission has announced again that some reflections on the reform of the package are ongoing. And the question is, do you think that the recent terrorist attacks in France and Austria could somehow affect the political agenda and the path towards more fair legislation on smuggling, such as preventing proposal for a more strict definition of facilitating to make their way. Thank you.
Thank you, Stefano. I think there is a question from Mario.
Yes, Barbara, many thanks. This is for Cesare. Cesare, yes, you're right. My suggestion at the end of the first session was perhaps the only way we can concretely look at is to discuss on how human rights can be improved in the current strategy of containment. And your answer to that is, well, in practice, what is happening is that the only improvement we can foresee, according to the Pact, is that we see more efficiency at the expenses of due process and human rights. So you basically reversed my view, and I agree. I fully agree with you. This is the clear trend. We have a clear trend towards a central role of border procedure through an expanded list of grounds that make asylum requests automatically inadmissible, because this is more efficient. And this has a clear implication, which is worrisome. It makes the administrative procedure and the individual assessment almost useless, irrelevant, and makes things more and more, faster and less respectful with regard to due process. Now, this issue is really relevant, the issue of inadmissibility. As long as the claim is dropped on inadmissibility grounds, you basically do not need much due process. This seems to be the logic that is embedded in the new vision, or relatively new vision. And the safe third country clause is prominent in this respect. I know you've worked on this, and therefore I just want to make a technical remark on a relatively recent decision of the ECJ, the FMS case of last May, where the court tried to defend not only the de facto observance of non-refoulement. You cannot consider a third country as safe, regardless of whether they de facto observe non-refoulement. But also the court marks a difference between the transit through a third country and the connection with it, the connection that is necessary in order to have this safe third country clause applied. Now, my question is this: in the mentioned case, the court insisted that the mere fact that an asylum seeker has transited through the territory of third country cannot alone, I quote, constitute a connection for the purposes of Article 38 of the Procedure Directive. The court was very elusive on this concept of connection. But what I found interesting is that the court here tries to somehow open a breach in the wall of automatic application of the clause. How do you see this? And do you see any prospect for a more careful specification of this concept of connection? Many thanks.
Thank you, Mario. I was trying to say you only have 1 minute to answer, but I think 1 minute is not enough to answer this question. This is really a big question. So, no, my question to Iris, my last question is for Iris, and well, it's the one I made before. So, are we still in the deadlock? I mean, financial resources should be the way out, but from what you said, are not enough, or I don't know. I think the problem is not that the resources are not enough. So can you say something about this? Is there a way out? Can we see the light at the end of the tunnel or not? This is the question. So you really have few minutes to answer, so keep it brief.
Okay, sure.
Thank you.
So first of all, we are currently in a deadlock in terms of the negotiations on the new MFF. And the reason is because the member states, the Council, and the European Parliament cannot agree on the size of the total budget. So it's not connected to the migration and asylum budget. It's more connected to the size of the whole of the budget, first of all, and with some other issues like increasing the fund for Erasmus students, for research and things like that. So the problem is that if they manage to make some kind of a deal in the next week or so, that's still bearable in terms of, you know, trying to start to use the funds on time. If not, this will mean the prolongation, which is very problematic also because of the COVID-19 pandemic and the use of the recovery fund. Now, your question, I think, was directed towards something else, right? So it's not so much about the money. You know, the money is a problem. And I think that generally speaking, the EU should spend more money on helping member states in terms of migration and asylum management. And this is something that a number of member states would really need and that they would be grateful for. And when you look at the trend goes in a different direction. So that's one problem. And the other problem is something that has been raised not only by me, but by a number of speakers today, and I'm sure it will be also discussed tomorrow, and that's the principle of solidarity. So it's not only about, you know, how much money a particular member state, the host member state, gets from the EU budget, but it's also how you kind of try to divide the costs among member states in a fair and balanced way.
Thank you. Also, Professor De Bruycker suggested this and outlined the contradictions in the overall perspective. Thank you, Iris. Thank you. So I think it's the time for Cesare to answer.
Barbara, may I interrupt you? Because I guess you missed some people in the list. Rosa Stella and Cassarino were in the list, wanted to intervene. Perhaps we can.
I cannot see there here. Okay, thank you.
We can finish 20 minutes late. It's not a problem.
Ah, okay. So sorry, Rosa Stella, really sorry. I didn't see because the chat is so fast. I mean, thank you.
No worries, no worries. Can you hear me?
Yeah.
Yes. So I am Rosa Stella De Fazio. I am a postdoctoral researcher in EU law. Currently, I am a visiting researcher at University of Zagreb with Professor Iris Gordner-Lang, who I thank you again, Iris, for inviting me, and also for inviting this very interesting conference of today, who opened a lot of interesting issues and gave me the possibility to broader understand them and the dynamics who are behind the new pact on migration and asylum. Well, several times I researched some EU law acts who, in dealing with immigration and asylum policies and relating question, also had an impact on the fight against terrorism. And I mean, in my opinion, the new pact on migration and asylum is above all aimed at balancing the solidarity and responsibility and the responsibility among states in migration and asylum, of course, but seems not to pose so much the attention, the focus also on balancing with some more adequate security.
Rosa Stella, can you hear me? I think you have some issues with your microphone or the audio, and thank you. Now we can hear you.
Okay, and yes, so I wanted to know if your opinion of any of the speakers, this is a problem dealing with a separation by the European institution of the two fields. I mean, if the European institution have finally decided to separate the field of immigration and asylum from the field of counterterrorism and security in EU law, or it is simply a matter of a more specific instrument of the European legislation in the field of migration and asylum. Thank you.
Thank you, Rosa Stella. I think we also have Jean-Pierre Casarino.
Yes, hello.
Sorry.
No, it's okay. Don't worry. Come on. No. Thanks to all the speakers, really, and very interesting session. I have a question, a comment, first of all, which is addressed to Niovi Bavula. Thank you very much for your presentation, which I found extremely interesting, also because I deal with statistics. And I just would like to share. I would like to share a feeling, I would say, especially with connection to the relationship between data processing and decision making. So the Commission very often, complains about the lack of accurate data, which is absolutely true. Even Eurostat, when we look at the metadata of Eurostat is the first, to complain about the inaccuracy of the definitions which are used by them. We know that, of course. But there's something which is really puzzling to me. Even when there is an impact assessment, which is asked by the Commission, despite the lack of evidence from, I would say, a statistical point of view, well, decisions are anyway taken by the Commission in total contradiction with its own statements. One. A second aspect, which is so, again, disturbing and puzzling, it's when the Commission in the new Pact on Migration and Asylum declares that, well, there is a problem with AVR shopping, you remember, and then it also contradicts itself a few paragraphs later, saying that actually we have no evidence of this problem. Then my question is very simple. Don't you think that there's, the way in which all these statements are made, which in my opinion is extremely, if I may, casual, raises a lot of concerns, regarding the validity of the statements of the Commission. That's why, it's a question which is related to this interconnection between data gathering, data processing, and decision making. So I would like to know your point. You're an expert on that. Thank you.
Thank you, Jean-Pierre, if I may. I think that so many questions are the evidence that the discussion is really very interesting, and the conference too, but we don't want to be impolite. So I think that anyone who wants to leave or needs to leave is free to leave. And I really want to thank everyone for being with us. But who wants to remain, please, we are happy if you stay with us. Okay, so now we will follow a reverse order. So Cesare, then Niovi, and then back to Professor Mitsilegas.
Okay, thank you. And thank you, Mario, for the question. It's a very complicated question. I think, as it often happens, our differences are more apparent than real. And I will take just your more precise question, the last part, to try to make my point. Yes, of course. So the recent a decision about what is a sufficient connection, is transit a sufficient connection, is of course a very interesting opening for challenging the application of the principles or of the concept of safe third country. Well, if I think about this as a defense, as a lawyer assisting an applicant, for sure I would use that argument. It's a very good argument. But then if my whole point, I mean, that my speech was very short, of course, as it had to be. But these issues are very complicated. When I look at these problems, and I've dealt with in articles a little bit more in depth, the impression that I have is that the more I study, the more I think about it, the impression that I have is that, okay, we can build what Professor Spiekerberg called sophisticated procedural architectures, I think, in an article of a decade ago. And then we need, because it's part of our culture, to say that these must be compliant with human rights and human rights obligations. But then if you look into this, if you really have to guarantee and to apply all the guarantees in a very strict way, then the procedure is not efficient anymore. So it would be better to have, like, for example, I know this might be not very popular, but for example, the idea of concentrating asylum and return in one decision, I think this is a good idea. It's not a bad idea, huh? To not have, you know, multiple, but then it's a good idea if you give the people the time to prepare, the time to prepare for the interview, the time to, you know, to go through the process, to understand where they are, who they have in front, what is the stake, and then to prepare their defense, and so forth and so on. If it is in a very accelerated procedure, when you have 2 days to prepare your appeal, then it's just a mockery of fairness. It's not real fairness, and also this idea that you have a first assessment with the screening procedure, then you have a second assessment in few days. The administrative part, the first stage of the exam, of the application, has to take place in very few days. How can you access? How can you do this properly? It's impossible. It's a complex. It's by definition it's complex, unless the prophecy is self-realizing. So since the beginning, you have already decided that this is unfounded or inadmissible, and then you just have a procedure to justify this ex post. For example, by applying the wrong burden of proof. There is no presumption. That's very clear for a lawyer, that there can be no reversal of the burden of proof in asylum procedures. So that's a little bit my doubts. I would like to have efficient procedures, but I can't see efficient procedures that are not coupled with sufficient guarantees. Like, the sufficient guarantees are an inbuilt element of an efficient procedure, because otherwise it's just, you know, repeating, because you say no, and who has a no will challenge that. And I will stop here. I wanted also to add a short notice, a short comment to Rosa Stella. Hello. To Rosa Stella comment. I agree. I agree with you. I understand your point. Of course, this is a sectoral proposal and so forth and so on. But if you look at the proposal, there is the security aim, or the security topic issue is there, because the danger to national security of the applicant is one of the grounds for drastically reducing the procedural guarantees at the point that even the asylum application can not have carry with it the right to remain. So there are several provisions that use security as a ground for reducing guarantees and due process. Thank you.
Cesare, I know that this is pretty unconventional, but I hope not unfair. Dario Daviti has a question for you connected to what you have just said. So I hope the other speakers are okay with my decision to to collect this question now. Daria.
Thank you, Barbara. And I'm sorry, I didn't want to jump procedures. I'll try to...
No.
Thank you. Cesare, I agree with you on the fact that fast tracking obviously presents a lot of challenges and it's problematic in so many ways. And I agree with you that sufficient guarantees must be inbuilt in efficient procedure. But then where I don't understand you is where you say that asylum and expulsion procedure should be taken simultaneously. How would you have those guarantees when this is taken simultaneously?
No, I said that I think that the having a return decision together with a rejection of the asylum is maybe a good idea in terms of effectiveness of the procedure, but this is only so if the procedure itself is a fair procedure.
But that would then mean, if I may, that would then mean having an appeal and another appeal and a judicial review and having the whole of the process until the end, because an asylum application is only rejected when it comes to the end of the asylum process.
Yeah. This is. See, I think I didn't express. I'm sorry.
Okay, sorry.
I didn't express myself correctly. Like if we have a full asylum, a full and fair and really adherent to all the limits, inbuilt limits, inherent limits to dealing with asylum. So this guarantees that the outcome is fair. So if it's a denial, it's a real denial. The person doesn't have the rights.
Yes.
And even before that, my starting point is that we can reason about efficiency only if we have legal venues. So we separate the paths. So that's the first part. The second part is that then at that point, I think it's fair to think that the expulsion decision is taken at the same time, because that's a legal and necessary
of the very end. Okay, I understand.
Is the necessary legal consequence of the rejection.
Yeah, I understand.
Whereas, for example, in Italy, it's not like that. It's very complicated, and this is actually a dispersion of resources and also judicial attention or time.
Yeah, no, thanks for the clarification.
Okay, thank you for the question.
And there's also secondary protection in between, and this procedure is connected to the other. So this is really interesting. Okay, so now is the time is for Niobe to answer.
Thank you so much, Jean-Pierre, for the very insightful comment. Absolutely, I fully agree with what you mentioned. In that respect, I have a couple of comments. Indeed, Eurodac suffers from not exactly inaccurate data in terms of the fingerprints. That's one issue that may happen because sometimes the procedures are too hasty, the quality of fingerprints is not really high. A key problem is that certain member states try to circumvent their obligations under Dublin by postponing and forgetting to register the fingerprints on time so that people can move secondarily to another member state, make an application. In the process of application, no return result will be in Eurodac, and that's a way of evading their obligations under Dublin. And this is notorious in certain member states, and it has been well documented. So indeed, there is a problem on the quality of data, and I think problematic data will also and inaccurate data will, as you mentioned, as you hint, they're going to have a collateral effect in the production of accurate statistics, which are there and which are embedded in the Eurodac proposal explicitly to legitimize all the new measures and to basically provide evidence that what initially was adopted is actually working, and it was good that it was adopted. So there is, at least at this point, there is no evidence-based policy. But in my view, a system, a Eurodac cannot, and any system, collection of mass amounts of data of vulnerable groups of individuals cannot be justified for the sake of creating evidence-based policy. It doesn't work like that. It's evidence-based policy that justifies the adoption of measures, not the other way around. And we cannot launder the data, and we cannot repurpose data in order to retrospectively legitimize the policies. So I will leave it to that in order, because I understand we'll have very limited time, and I'm happy to discuss it further with you if you so wish later on.
Thank you, Nevi. Thank you. So now the floor goes back to Valsamis, if I may.
You may, of course.
Yeah.
Thank you very much for giving me the last word as well. So thank you for the questions, Francesca and Stefano. It's nice to see you both. Francesca asked a very interesting question about whether the criminalization and, if you like, control or management of civil society are mutually exclusive or not, and whether the Commission has changed its strategy. I think certainly criminalization is not going away. I think certainly the Commission is trying really to keep a balance, to say we're not the bad guys because we recognize the problems, but obviously there is no political will to change the legal framework and perhaps to decriminalize a bit. This has never happened in EU law, that a legislative instrument is revised to limit criminalization. I think this could be the first example, but it will not happen, I think, politically. But certainly the Commission is trying really in the guidance to say that we know that this causes problems with international law, and that, you know, we give some guidance to states as to what to do. What is interesting to see is whether the Commission will actually look in its role as guardian of the treaties on what is happening in member states, and especially how this legislation is used to prosecute civil society. But I agree with Francesca that there is a trend towards greater control and monitoring of civil society, and that causes a number of big human rights questions, I think, and it's not really discussed. It is within the process of stigmatization or demonization of civil society, and the two are always linked, because the more I think you demonize, the greater the danger also for things like abusive prosecutions and so on and so forth. I think we have a number of prosecutions that are, it's quite interesting to see what the outcome will be. The question, I think, about the monitoring and the registers and the codes of conduct and so on and so forth is also the fact that we can discuss on a constitutional level the extent of EU competence in that as well, because, you know, I'm sure there are voices that are saying that the EU does not really have the competence to regulate this to a great extent. Hence, I think the publication of a recommendation by the Commission at this stage. Now, on Stefano's question, the related question on terrorism, what is interesting actually is that although in general we have elements of securitization of migration, if you like, and I'm sure Novi can give another presentation on how this is reflected in the context of the European database of the use of the visa information system for law enforcement purposes, interoperability, and so on. In this specific field of smuggling, I think the Commission has chosen the narrative of the dangerous smuggler rather than of the smuggler that carries terrorists, in a sense. This was, I think this discourse appeared a lot after the latest Paris attacks a few years ago, but it's no longer there. So I think the security aspect appears elsewhere. And I think that is something at least to be commended, that in the discourse on the criminal law, this is not really there very prominent. And I'm not sure that this will change that much now, but I think you will have a lot of focus on restrictions of movement and on greater surveillance.
Thank you. This is the end, I must say. It was a pleasure being together, really. A very interesting discussion. I think everyone had the pleasure to be here till the last moment, the very last moment. The follow-up is tomorrow for the last two sessions. I see here one of the chairs of tomorrow, Emanuela. Hi. And so really it was a pleasure. And thank you for being with us. Thank you to the organizers. Thank you. Bye.
Thank you.
Thank you. Good night. Thank you.
Thank you. Bye. Bye.
Bye.